Good morning again, Brigadier.
Good morning, Advocate uMnisi.
Thank you. Now, before we proceed on our last aspect, I just want us to take a journey back a few miles. You told the court that the reason why you did not use this form XX that was exhibited at court was because there were no such instructions that you should use it from the state. Number two, if my memory serves me well, you indicated that there were no specific directives that when one interviews a suspect or a person in relation to a particular case, this specific form must be used, and that on top of that, there are various forms that are being used at the police station, to which you also made an offer that you could bring some of those forms here in court so that we can go through or see ourselves that what you say is correct, that there were various forms that are used.
Before you respond, be reminded that they're still under oath.
Yes, noted, my lord. My lord, so let me start with the last part. Yes, I did offer that I can bring different forms, warning statements, SAP 3M, which I got the feeling that it was not accepted. That's the first part.
Mangizoqala-ke la kulona ugcina-ke umbuzo bengishilo-ke ukuthi-ke ngalekelela-ke ukuthi ngize-ke nama-form ahlukene-ke la enkantolo ukutshengisa-ke lokho bengikhuluma ngako ama-SAP 3M ama-warning statement kodwa-ke engikutholile-ke ngithole-ke ukuthi noma ngizwe ukuthi-ke akwamukelekile lokho.
And I do confirm, my lord, that I said they are different. There is no prescribed. So the correct context was that there is no one specific warning form in terms of a booklet, like the one that Advocate uMnisi referred me to. There are different ones which are currently in use. And this exercise of bringing them, my lord, was to show that this is not the only warning form that is available in the SAPS.
Nokuthi-ke ngishilo ukuthi-ke kunama-form ahlukahlukene-ke asetshenziswayo-ke uma kuza-ke kuyitatimende zesixwayiso noma-ke ama-warning statement. Yingakho-ke bengishilo ukuthi-ke ngingeza nawo ukukhombisa nokutshengisa ukuthi-ke ama-police station-ke ngokwahlukana akusetshenziswa iform eyodwa noma le abekhuluma ngayo yena-ke u-Advocate uMnisi.
Secondly, my lord, I did not say when it comes to the interview of accused 2 specifically that I chose not to use this form. I was responding to the questions that were flowing from the form that I was referred to say this specific form says there must be an interaction between the police and the prosecution, and therefore after that you go and then obtain the warning statement. So it was flowing in that aspect, but insofar as my interaction with accused 2, I said I didn't complete the form. I made it very clear as early as last year, my lord, that there was no warning statement completed at that time when I interviewed him for the first time. However, at a later stage, a warning statement was taken from him.
Kodwa-ke futhi-ke ukuthi umbuzo noma ukuthi-ke ngenze ngendlela thizeni-ke uma kufikelela-ke na-ke umsola wesibili-ke nalokho ngikuphendulile-ke ukuthi-ke kwakunganyaka ondlule-ke ngisho ukuthi-ke leyo form angiyisebenzisanga-ke kuyena noma-ke angikaze ngiyigcwaliseke nokuthi ngiyibhale kodwa kamuva-ke sengiphinde ngiba nenhlolo khona naye-ke ila khona-ke i-statement noma-ke i-warning statement ngayithatha kuyena.
And then thirdly, my lord, is that indeed I did say that when police conduct interviews, I even referred to the mere interviews that are conducted by the police when they conduct arrest on the street, my lord. I even said at that stage, be it detective members or uniform members, they will never have such a form. They will conduct an interview with the suspect in question. They may follow up certain things that he say, which may lead to the discovery of evidence. Then that form will not be available only when the person is detained and now is being prepared to be processed, for court, or there's that directive by the NPA. Then the form gets then completed.
Nokuthi-ke uma kuwukuthi-ke umuntu uhlangana-ke namaphoyisa-ke noma-ke amaphoyisa akhulumisana nayo noma kuwukuthi ama-detectives labo bagqoke i-uniform-ke uma bekhulumisana naye-ke ayikho iform lapho-ke akukho la khona-ke izogcwaliswa khona-ke kodwa kamuva-ke uma sekuwukuthi manje umuntu kufanele ayovalelwa-ke itokisini uselungiselela futhi ukuthi ayobingelela imantshi nokuthi sewukhona-ke umlomo okuya kubona-ke abashushisi ila khona-ke manje leyo form leyo uzothi ingene khona-ke.
Now, my lord, a practical example, which is something that has been discovered or disclosed to the defense. In particular, I'll go specifically to the one that relates to Advocate uMnisi's line, so that he will understand that this example.
If I want examples, I'll request you to give examples. I don't mind if you're going to speak about accused number 3. We'll come and deal with this case. But then, speaking about accused number 3, when I get into his case, I specifically asked you the question that I asked you. Now, what is the necessity of you to try and give an example?
Because it relates to the question of whether this form can be used at the initial part of the interview, my lord. And I wanted to be specific because there is an incident where there was.
So you're basically saying, Mr. Gininda, can you please not argue with me? If there's a point that you want to argue, request you to argue it through the state. The state is here to present your case on your behalf to the court. You don't argue with me. Because there are so many things that I'm going to raise with you and not be able to answer them in terms of argument. That is the procedure here at court. I don't have to argue with the witness, and the witness don't have to argue with the counsel. If there's an argument that needs to be put before court, it should be through the state. Do you understand?
That's a good place, but I think that is unfair. He's trying to elaborate, to draw parallel between the question that is being asked and what happened in this case, just to try and demonstrate the answer. There's nothing wrong. It's something that there's nothing wrong with it. He should be entitled to elaborate on his answer, just to draw parallel to explain his point.
Yes, my lord. So my lord, I'm saying, in what we've discovered, just to illustrate this point clearly and with factual evidence. Now we've disclosed Cleveland case 96/2/2015. Advocate uMnisi is aware of it. In that docket, it is clear if you go with, I won't go to the merits, but I'm just going to focus on this warning statement, which is similar to the booklet that Advocate uMnisi is showing us, my lord. That
is irrelevant, my lord. You're not talking about Cleveland case here. That is irrelevant. Now the court wants to hear irrelevant evidence.
It's not irrelevant because it's
No, it is irrelevant. We're talking about Cleveland case, which is not part of this proceeding.
It's not irrelevant because he's talking about a form which he testified to say that there is no single form applicable. There are several examples of these forms.
Thank you.
And then he wants to give you an example which he quotes.
Thank you, ma'am.
Now, my lord, I'm saying in that which we've disclosed, my lord, I'm referring it to because I know we've disclosed it to the defense. Accused, it's alleged in that form in the docket. Accused 3 was interviewed. He came into contact with the police on the 9th of February 2015, where he interacted with the police, and subsequently it's alleged that firearm and ammunition was found. If you look at the activities...
That is irrelevant, my lord. That is irrelevant. Now, Mr. Gininda says it is alleged that he was interviewed. Now he's talking about hearsay. That's the irrelevant part of it that I'm speaking about, my lord. And the court said, let him explain.
Yeah, ask any questions, Mr. uMnisi. I will ask him when it's being taken through cross-examination by all of you. Okay.
Thank you, ma'am. So, Brigadier Gininda, you're basically saying that the usage of this form XX starts to play a role when a suspect is being prepared to go and appear before a magistrate. In other words, the first time that these forms gets used, it's when the suspect, after having been interviewed in so many ways, first time that this form gets used is when you're not prepared to take it to court.
No, my lord, that's not what I said. And can I ask, my lord, that Mr. uMnisi give me an indulgence to explain my answers, because my answers relate as to how he asked me the question. You see, like the part that he's putting now is not what I said. And when I elaborate what I've said, it will look like now I'm venturing into issues he didn't ask. And I ask him just to be patient, because I'm only going to motivate or explain insofar as what he asked me, my lord, not out of that terrain. So if you can just be patient with me as I am. When he puts questions to me, I don't interject. But it seems there's this intention to confine. You see, my lord, this is what I'm talking about, my lord. I'm not done saying my part. Mr. uMnisi is interjecting. I'm not so sure how far we can take this. My lord, I've explained. I've said, when this form gets completed, the first part to say is when the suspect or a person is processed before the appearances. That's that part. But I've also indicated that when there's a directive from the prosecutor, when the prosecutor says to you during the course of the investigation, go and obtain a warning statement or this explanation from this person. This is now before a decision is taken to prosecute a person. Then the form will be completed. So I didn't only refer to one part, which is the assertion I'm being given now, my lord.
Engikushilo-ke mina ukuthi uma-ke le form ke isisetshenziswa-ke nanjengoba manje mina-ke nginikezwa nje okodwa, kodwa mina ngisho okubili-ke ukuthi ila khona-ke kulungiselelwa khona-ke umsola sekuwukuthi-ke manje ngaphambi kokuthi-ke ayo-ke enkantolo. Okwesibili-ke uma kuwukuthi-ke kukhona-ke okubuya noma okushiwo umshushisi-ke ukuthi hamba uyothola lokhu kulo muntu, noma-ke yilapho-ke manje leso statement noma leyo warning statement leyo izongena khona.
Thank you. Now, let me get you right. The time at which this form, according to you, is to be used is when the prosecutor says or gives instructions that you need to go, that the police needs to go and take a warning statement from the suspect. That is instance number 1. Instance number 2, it is used when the suspect is being prepared to go in process to go to court. Did I get you right?
Yes, those two, or when the police state, my lord, are of the view that now they will want to present the matter to the prosecution. That is in an instance where you've conducted an investigation, like in this instance, my lord, specifically to this matter. I've completed the form before, in relation to the accused, before the matter was presented to the DPP. So those are the instances that when the matter is presented, then the DPP then will have an insight of what the accused or the suspects are saying in relation to this matter.
Iloko kokubili ngikushilo uma welungiselela ukuthi ezobingelela-ke imanje nokuthi-ke nabashushu sebeshilo ukuthi bangafisa ukuthi bathole lokhu. Lokwesithathu-ke nokuthi-ke manje uma usuthi-ke icala leli-ke noma-ke khona kuzobhala nanjengoba nami ngenzali kule cala leli ubhaleke ubhalela kubona-ke beshushisi noma ukuthi-ke usuyokwethula-ke icala leli kubona-ke.
So according to you, those are the instances at which these forms comes into play or is being used.
Yeah, but I'm not saying, my lord, is the only one. You evaluate each situation on its merit. But these ones, yes, are what you will actually look into. Because like I said, the third one is something that I embarked on. The other one is in preparation, before the appearances, because an accused person or a suspect can't appear before the form is completed. The third one that I referred to is when the prosecutor asks you to do that. But obviously each matter varies, my lord.
Yebo iloko engikushoyo kodwa awukwazi nje ukuthi uncike nje kuloko ukuthi ikona lokho kokuthatha kuphela ke ngoba ke ubheka ke isimo kodwa manje nami ke ngenza ke lana ngenza ngalendlela engenza ngayo nokuthi futhi ke umsolwa akakwazi ke ukuthi angayobingelela ke imantshi leyo form leyo ingeka gcwaliswa.
Thank you. Is it true that you also told the court that there are no specific directives with regard to which form should be used because, as you mentioned, there are so various forms at various police stations which they can use? Is that what you said?
No, that's not what I said. That's not what I said. Absolutely not. I've said, my lord, there is no prescribed, there is no specific form. The instruction that a warning statement must be used is there, but there is no specific prescription that says this form, for example, the booklet that Advocate uMnisi gave to me, is the only form that must be used when it relates to the warning statement. So I'm referring to the form, not that there is no directive that the warning statement must be used. It's not what I've said.
Angishongo ukuthi cha akukho okulawulayo noma ke okuwumthetho ukuthi akwenziwe lokho. Yebo ukhona umthetho wona ukuthi i-warning statement kufanele ithathwe. Kodwa engakhulumi noma engasho ukuthi leya form angitshengise yona Advocate uMnisi ukuthi iyona kuphela noma yile ekufanele ukuthi kube yona esetshenziswayo.
Mr. Gininda, understand my question. I am asking you, according to you, there is no specific instruction or a directive that says that it is only this form that must be used when an interview with a suspect must be conducted.
Yeah, I understood your question differently, my lord, but my answer is simple, my lord, as I've said.
Mr. Gininda,
can I finish my...
Before you answer, do you understand my question? Before you answer, do you understand my question?
My lord, can I be given an opportunity to answer?
Do you understand my question, Mr. Gininda, yes or no? So that I can explain it or I can repeat it. Because I don't want you to understand something, to answer something that I did not say. Because I've just heard you now that you are repeating my question in a way that I did not ask it.
Can the witness be allowed to answer? How can he be asked whether he understands the question before he has even ventured a response? The witness should first be given the opportunity to give an answer.
Let me repeat my question, Mr. Gininda, Brigadier Gininda. According to you, there is no specific policy or a directive or instruction which says that this particular form that we are using is not the only form that should be used in an instances where there is an interview with a suspect.
My lord, I thought I was answering that. According to the national instruction, maybe let me be specific, not according to me. I don't own the SAPS, my lord. According to the national instruction, and I can refer to that if that is needed. We can adjourn, or during tea time and refer to the specific standing order. There is no prescribed or a specific warning statement to say this particular warning statement is the only one that you can use when you take a warning statement. That's what I've said before, my lord. It's what I've been saying before. And if my recollection, my lord, previously last year I was asked by Advocate Baloyi to assist with our legal services to provide such a standing order that confirms that there is no prescribed, and I did that, my lord. So we're doing the same exercise again.
Mina ke siyana ke oku noma ke isiphoyisa sona ke esam kodwa ke kunabizwa ngokuthi ke i-national order ekuyiyona ke ikhipha ke imithetho ingalekelela ngeza nawo ke unyaka odlule sikwenzile ke lokho sichaza khona ke lokho ukuthi ke akukho nje kuthizeni okuchaza ukuthi yilena kuphela iform ekufanele ukuthi beyiyona esetshenziswa i-warning statement.
So you're saying according to a national instruction, because it do not own SAPS, there is an indication, or in terms of the national instruction that you're referring to, there's an indication that this should not be the form that should be used, as there are other forms as well that can be used when an interview with the suspect is done. No,
but that's not what I'm saying, my lord. I'm being quoted out of context. I did not say the national instruction says that form must not be used. That's not what I've said. I'm saying the national instruction is saying there is no prescribed form. There is no specific form in the warning statements that can be used. In other words, there is no, I don't know how to explain it, my lord. There is no form where the instruction says this is the only form that you must use when you take a warning statement. Not that that form must not be used. It's not what I've said, my lord.
Angishongo ukuthi leyana actionary kufanele ngasetshenziswa kodwa angithi akukho la kusho khona ukuthi yile noma kune form thizeni ekuyiyona kuphela ekufanele ukuthi isetshenziswe.
Thank you, Brigadier. And you said you made that national instruction available to the state.
Yes, I was asked then by the state during that time, and I engaged with our legal services. It was communicated to the state advocate, my lord.
Nangicelwe-ke kunyaka ondlule uyena kumshushisi ukuthi-ke angikhulume-ke nalabo-ke bezomthetho emaphoyiseni ukuthi-ke basizeke ngakwenzake lokho kunyaka ondlule.
My question is, you then made available that national instruction to the state.
But that's what I said, my lord. I just answered that.
Yilokho engiceda ukuphendula-ke manje ngibuza kona ukuthi-ke ngaba ningawunika yini umbuzo.
As it please the court, my lord, I'm going to request through the court that the state assist us or give us a copy of that national instruction. Thank you, my lord. And further on, Brigadier Gininda, I note that when you made an offer to make available those other forms that might be used in an interview with the suspect, I said to you that might not be necessary. But subsequent to the discussion that we had now and the making availability of that national instruction, if you don't mind, and with the leave of the court, I'm going to request you to make available those forms to us, the defense, if you can. Thank you. Let's pay your offer.
My lord, as we said by the leave of the court, if the court asked me to do that lately, I offered initially and it was rejected. Now I'm being asked to do it again. Let them do it, my lord. I offered on my own, precisely to remove this suspicion and this misunderstanding. That's what I was trying to avoid. Now we are here again. But yes, my lord, I will assist. By tomorrow, I'll have such forms available, my lord.
Bekuyinto-ke ebize nami-ke bengishilo ukuthi ngasengalekelela-ke kodwa-ke kwanqatshelwa-ke kodwa manje sesibuyela khona lapho kodwa uma kuwukuthi inkantolo ithi-ke angize nawo-ke lawo mafomu ngizokwenza-ke lokho kusasa.
Thank you. Now let us proceed from where we ended on Friday. Now you told this court that you did not know how Mr. Mjayiko get to know about accused number 2's incarceration. So
that is correct, my lord.
So iqiniso ngishilo ukuthi-ke angazi ukuthi uMjayiko wazi kanjani ukuthi umsolo wesibili wayeboshiwe.
And you further told this court that you received a call from the police station wherein they informed you that there's an attorney who wants to consult with accused number 2. So, and that was Mr. Mjayiko. You quickly went to the police station and you found Mr. Mjayiko.
That is correct, my lord.
Ngasho nokuthi-ke ngathola ucingo police station ukuthi kwakunommeli owayelapho-ke impela-ke ngaphuthuma ngaya khona police station ngamthola elapho Mr. Mjayiko.
And did you ask him how he knew about the fact that accused person is been arrested, accused number 2?
No, my lord. There's what you call attorney-client privilege. I can't venture into that. It's not my terrain. There's no way I would have asked him that, my lord.
Akukho la ngangambuza khona-ke ukuthi wakwazi kanjani ukuthi wayeboshiwe umsolo wesibili khona-ke lokho ukuthi-ke kuphakathi kommeli kanye futhi naloyo ammele-ke ngangeke ngiwubuze loyo mbuzo loyo.
And furthermore, my lord, it is the accused's constitutional rights or any suspect to appoint or engage any attorney that he so chooses. So it's not for me to interrogate that, unless if during the time when I was giving him his constitutional rights, he says to me, I need an attorney, a legal representative through the state's at the state course. Then that's the only part where I will play the assistance of getting the legal aid board insofar as contacting him. Thereafter, my presence would have been, would have been out, my lord. In this instance, I was not involved, and there was no need for me to be involved.
Kuyilungelo lakhe-ke umsola noma lowo oboshiwe ukuthi-ke ayiqokele ummeli ozomsiza noma-ke ozommela uma kwakuwukuthi-ke wacela mina-ke noma asho ukuthi-ke udinga ummeli wombuso kwakula engangizomsiza khona-ke ukuthi nje atholeke ummeli loyo bese-ke kuyaphela-ke okwami lapho.
Thank you. The testimony before court, my understanding of it is that for the better part of his arrest, or immediately after his arrest, accused number 2 has spent most of the time with Sergeant Mohane and Mabena. Do I understand that in a context in which it should be understood?
I'm not sure, perhaps when the question is saying the better part. My understanding of the situation, he was arrested by the 2 members,
yes,
and he was kept at the police station. Sergeant Mohane and Mabena were not stationed at those police stations where he was kept. So perhaps I don't understand, because if then you ask me where did he spend most of the time, I will say at the police station where he was detained, my lord. But perhaps I don't understand the context in which the question is being asked.
Mhlampe-ke angizwa kahle ukuthi umbuzo ubuzwa kanjani uma kuthiwa-ke isikhathi esiningi-ke wayesithetha naye-ke uSergeant Mabena kanye noSergeant uMohane ngoba-ke ebegcinwa-ke noma bevalelwa-ke e-police station bona-ke abekho kulezo police station lezo. Mhlampe-ke umbuzo lo engawuzwa kahle.
Thank you. Now, did you at any point receive a report from Mr. Mohane, another team member, that there was a request that came from accused number 2 to them to make a phone call to his legal representative?
No, I don't think that was communicated. I have no recollection of that, my lord.
Angikhumbulike lokho noma ngikhumbula ngitshelwa ukuthi-ke kwakunesicelo esenziwa uyena-ke umsolwa kula maphoyisa akhe ukuthi-ke ufisa ukuthi axhumane nommeli.
Thank you. And just to confirm that, that is also not the testimony of Mr. Mohane. He never told Sergeant Mkhane never told this court about that incident. Thank you.
Understood, my lord.
Now, is there an instance in you trying to collaborate, whatever that you could have been collaborating, in which you found that accused number 2 requested at the police station or at the various police station where he was housed an indulgence to make a call to call his legal representative?
So the answer, my lord, is no, and that's the first part. To answer it specifically. Secondly, the corroboration I was referring to relates to Exhibit HH and JJ. What is contained there, not the circumstances of his arrest and where he was kept. It's in relation to Exhibit HH and JJ, my lord, specifically.
Examine kwakho ukuthi uhlanganiseke lokho okuhlanganisa ke ingaba wathola yini ukuthi ke umsolo wesibili waqala ke ukuthi axhumane nommeli wakhe. Cha, ngizophinda ngisho ke kodwa ke uma bengikhuluma ngokuthi ke ngihlanganiseke mangikhuluma ke ngestatement lezi uHH kanye ke noJJ ngingakhulumi ke ngezimo mala nokuboshwa kwakhe noma izimo aboshwa phansi kwazo.
The only time, my lord, where I had to look at the circumstances surrounding his detention and where he was kept, it's when I was making arrangements to get the OB, the occurrence book, the ACP-14s, and the ACP-14 insofar as his detention, my lord, and the condition in which he was detained. That was in preparation of the case and subsequently for the trial within trial. So those are the time. But the issue of the attaining and where instructions, how, like I said, my lord, I felt it's not a space that I should get into, my lord.
Kodwa la khona ke engabheka khona ke manje izimo malana nokuboshwa kwakhe noma ke oyivalelwe ngaphansi kwazo ke ila engangisengibheka khona noma ngifuna khona ke incwadi ke ama ACP-13 ama occurrence book lokho ke kodwa ke ukuhlangene nommeli wakhe ngacabanga nje ukuthi ke ayisikhona ke la ekufanele ngiye khona lapho.
Thank you. Now, when you went through those occurrence books from the police station and other registers, did you ever find a hint that accused number 2, there was a point at which he approached those the guys at the police station and requested them to make a call to his attorney? That should have been described. So if it ever happened.
Well, yes, it's supposed to be, my lord. So
Yes.
so the answer is no. And the book that was used for legal services, my lord, for legal consultation, because the legal visit are documented in a different book than your occurrence book. That book, my lord, we did not succeed to find. So I didn't get a confirmation of that. The only book that we've got is the occurrence book. However, I can confirm, my lord, because I observed the section 205, and in the phone that was found in possession, or alleged to be found in possession of accused 2, there is a communication with Mr. Mjiako's number there with accused 2 on a certain date, my lord, and we can go into those records if perhaps there's a misunderstanding in that part.
Kodwa ke uma ke manje ke usubheka ke khona yini la owathola khona ke ukuthi ke kwaba khona ukuxhumana phakathi kwakho umsola kanye futhi ke nommeli ikhona ke incwadi esetshenziswayo ke la khona ke kuza abameli noma umuntu ezobona ummeli wakhe akusetshenziswa ke ama occurrence book noma khona ke incwadi esetshenziswayo kodwa leyo ncwadi ke asiphumelelanga ukuthi nisiyitholeke kodwa uma ke ngingaqhubeka ke ngithi ke uma kuba wona ke ama section 205 kuwona umakhalekhukhwini owatholakala ngene umsolo wesibili la kwabonakala khona ke ukuthi bakhona ukuxhumana aye nakho kanye naye uMjiyako.
Thank you, Brigadier. It's getting nicer. When was that call made, according to your analysis of that information?
My lord, I don't remember the specific details. Like I said, it's in the section 205. So I know that my attention was drawn into that when the analyst was analyzing to say this number and this communication is there. I think it's a please call me, if I recall correctly, my lord, to the attorney or vice versa. But my recollection, I think it was a please call me sent from accused 2 number to the attorney's number. And I can confirm that, my lord, obviously, if specifics are needed.
Ukuthi ke kwenzeka nini ke lokho kufanele ngibhekeke kodwa ngiyazi nje ukuthi ukuxhumana kwakukhona ke nokuthi ke umntwaningi wangikhombisa ke lokho ukuthi ke noma umsolo wesibili okuyena wathumela please call me kummeli kodwa kwakhona nje ukuxhumana okwakukhona.
That number, which accused number 2 allegedly sent a please call me to, which is now associated with Mjiyako, who confirmed that that was Mr. Mjiyako's number?
I think it's listed on the what do you call this, my lord, LPC or some of the documents that we have. That's where we got the number from. It's there. It's not in dispute that it's Mr. Mjiako's number, my lord, in the documents that are available.
Manje ke inamba leyo ke okuthiwa iyona ke ekwathunyelwa kuyona please call me ubanike owayiqinisekisa ukuthi inamba kaMjiyako leyo ngicabanga ukuthi khona ke nakuncwadi ke le LPC akusiyona ke into ephikwayo noma ephikiswayo ke ukuthi inamba yakhe uMjiyako.
Or if not the LPC, my lord, his company's letter, but I know it appears in those documents, that cell phone number.
Noma ke kuyona ke incwadi yenkampani yakhe kodwa ngiyazi nje ukuthi leyo number ikhona lapho.
So you're speaking, you're not sure, you're taking a case.
That's a good case, Lord. All this evidence has been placed on record. I don't know why this witness is now expected out of his memory to remember those details. If counsel is interested in that information, the evidence is there. Reference can be made to the witness. It cannot be expected of this witness now to rehash those details out of his memory.
That is the purpose of a cross-examination, to test the reliability and the credibility of a witness. He's just mentioned here that he's not so sure. That is basically speculation. I cannot be circumscribed in instances where I am endeavoring to test the credibility and the reliability of the testimony of a witness to say that if I'm interested in a particular information, then where should I go? I don't cross-examine myself. I am cross-examining this witness. Thank you, madam. I don't know if there's a follow-up to my response.
No, let me say that the evidence is on record. This witness is now expected to, out of his memory, to remember what is on record. We are saying if counsel is interested in the record is there, they get the running transcript, he can refer to the evidence. Now, this witness is saying, I'm not sure whether the confirmation came as a result of a letter from the LPC or his practice letterhead. Now, he's being told that he's speculating. The evidence is there. It cannot be expected of this witness to rehash that out of his memory.
Thank you, madam.